Hi, guys. Welcome to class 5 of Fundamentals of Legal Research. So, today in this lecture, we're really going to be going over case briefing in some detail on the particular aspects of it. So, the first part of this will be what we talk about in the book, and then I'll go on to the Stasky book. So, reasons, why we brief a case. So, we talked about this last week, but you would brief a case, to basically figure out what the case says. So, it gives you a structure for reading and analyzing what what the court is holding, what the legal issues are. You might be using it to keep track of your research. You might have in multiple cases. You might be wanting to use the research that you find in a written memorandum of some sort. Keeping track of a bunch of cases that you're trying to read. You're not going to remember them all, so you write a case brief. It's notes. So that's kind of what you're doing. You're supposed to just be summarizing the components of the case concisely, figuring out what the holding's on. So that is why we're doing it, and that's why we're learning how to do it. What we kind of talked about last week, what we have in a case brief, we have our facts. We have obviously the case name and the citation. We talked about that in Stasky last week, but we have our facts, we have our procedure, our rules, issues. Issues should come before rules. Issues, rules, analysis, conclusion, which is also, we call that the holding. That's what happened. So, who are the parties? What happened in the lower court? What is the legal question before this case? That would be your issues. What primary law does the court rely on? I'm going to change this right now because that bugs me. How does the court apply these rules, these laws to the facts of the case? And then what's their decision? What do they come up with in the holding? So that's kind of your components. And, the way I did it, just like we did it in Peterson last week, is just have outlines. I think of it as like, little hooks, and you put each little section on the right hook, and then you put it in order, and here you go. Here's your case brief. Okay. So I guess, let me go to the Hamy's book. Okay. Oh, taking a little time. Components, name and citation. Remember, we need our official reporter. The reason why we put our citation in the case brief is because that way, if we're using it later on, we have it. We can access the case again, the correct case. We can cite it in a legal document. Okay. Our judicial history, our procedure. Here it goes. How did the case travel through the courts? How did we get here procedurally? What was our prior proceedings? What happened? It also helps us to see what's being appealed and what order is being appealed. Sometimes the judicial history is more important than the underlying facts. Okay, so the underlying facts are the facts that are relevant to the court's reasoning a decision. Just how do we, what happened to get us to the point that there is a lawsuit? Issues, remember, it's legal issues presented to this court. So don't do what the jury found or something like that. Did the judge make a mistake? Make error, they call it, when it uh, denied that this piece of evidence be produced to court, or did the lower court error in denying a motion to dismiss, or did the lower court error in presenting this piece of evidence to the jury? All of that stuff. And remember, it has to be a legal issue, it has to be a question, and our issue is going to be combine both the law and the facts, right? Did it err when it held that these legal statements were inadmissible these hearsay statements were inadmissible, right? So that's kind of where our procedural facts that went into our issue. Okay, the rule is our primary source, our primary law or rule of law that the court relies on for their analysis or reasoning. So it could be any sort of primary law, case law, code, constitution, whatever it is. Just whatever they're really talking about. So you could have, so you put it out there and just a very brief statement on what the final holding is. And then we use more, we talk more about it in the analysis section. Okay, so this is the analysis section is the most important part of case briefs. It's like, I always call this like the NutriBullet. So you have your facts and you have your rules and you put them together in the analysis section. Okay, you're going to pull out all of the rules and see how they apply. Why did the court rule what it ruled? Okay, so you looked at in Peterson, we talked about the two rules and why. So you went through the elements of each of the rules, right? And under the statute, all of the elements were not satisfied because we needed that safeguards of reliability or interest of justice to be served. But under the common law doctrine, they were all served. So, okay. So those statements were admissible under the common law doctrine. So now the next question that the court had to answer is which rules, the common law doctrine or the code? And then they talked about the Illinois Supreme Court having the power over making the rules of the court. And, if the Illinois court made this rule or adopted this rule, then that should prevail. So that's kind of their reasoning, right? That's the analysis of the reasoning. So going through that whole part is your analysis or reasoning section. Okay, the conclusion or the holding, you can call it either thing, is the court's answer to the issue question. So what happened? The court erred when applying the code rather than the common law doctrine of forfeiture by wrongdoing, and therefore all of the hearsay statements should have been admissible. Something along those lines. Okay. Now this just tells you when we're writing a case brief, nobody cares what I think, right? It's all about what the court held and why the court held it. There's no like, I believe, so that in any kind of legal writing, don't put in the first person. Okay, so the name and citation, judicial history, this is kind of your little outline of how to do it. What primary law did they rely on, the analysis, the holding, or the conclusion? Okay, so Gideon versus Wainwright, which is in our Hamey's book. So if you go here, you say you're trying to find the facts and the judicial history. Oh, this is just like one way to do it, to find to go through it and you look at the first sentence in each paragraph as a way to kind of figure out what happened. But remember, we talked about that last chapter too. So it's one way, it's a quick way to do it. Is this what I want? Okay. Where's my Gideon versus Wainwright? Oh, it's not giving me the whole case. Where's 4.1? I guess this is it. It just doesn't look highlighted like it does in my hardcover text. Okay, so here's my facts. Well, actually, this is like my procedure in the syllabus. Florida State Court, there was a felony and they appeared without money and without counsel. Asked court to appoint counsel for him, but was denied. So you see, like, this is our procedure, which is part of our facts, but the underlying non-capital felony is actually not even important. So this is kind of our procedural history, which serves the purpose as our facts in this legal brief. Okay, and then here's he's claiming, did the denial of counsel violate the federal constitution? So no, they're not telling us the constitutional section here, but we kind of have a general outline there. Okay, here's our holding, 14th Amendment. And here we go. Here's our facts. Here's they're talking about the 6th Amendment, and so that would be in your rules section, putting in that. We can even write a note saying this is my rule. And then, this whole section where they talking about Betts versus Brady, and then Betts versus Brady would be the other one that they really rely on as your other rule and how they analyze it. So this is all your analysis. And then here is your disposition. Remember, disposition is what happens to the lower court decision. So they reverse that and remand it for further action. So reverse is really the disposition, and they kick it back. Our holding is up here. So that's just a real quick way of going through that. Our issues. Okay, so remember we talked about facts a couple of weeks ago, but remember that the facts are really super, super important to writing a case brief. We want to make sure that we only are including the most relevant facts, which we also call key facts. And the key facts are those facts that if the facts were different, the outcome would have been different. So say in Gideon versus Wainwright, he was an indigent defendant. He didn't have money to pay for an attorney, but if he was a rich guy, then maybe he wouldn't have a constitutional right to free counsel, right? So that would be a key fact, that the guy was unable to pay for attorney's fees on his own. So that's what a key fact is. If the facts are different, the outcome would be different. So when you're doing your analysis, you're applying, say, the facts of our case, our client's case. It's very important to determine what are the key facts, because if your key facts are different, then this legal doctrine may not apply. The rules, right? Betts versus Brady, the 14th Amendment, and then applying those to the facts at hand. Just some general notes. Remember, the purpose of a case brief is not to, argue for one point or another. You're just there to say what that case said, to help you or another reader determine what the law is on this issue and what this case actually said. So if you're just writing the case brief for yourself, you can do abbreviations, bullet points, whatever is helpful. If you were doing this, say, as an assignment for me or another instructor in our program, use complete sentences, abbreviation, don't do proper citation. Don't do a half-baked job. Okay, what was this practice on page 461 that I have written down? Boom, 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 boom. Oh, this is fun. So you can kind of do this on your own. I won't waste our time right now with this. So you go to Appendix 8H to find these cases, and then you fill in the blanks. So here are just what are the facts and what's the conclusion. So that's, if we were in class, I would have you guys work on that together, but we don't. So we don't have class, so you can work on that on your own, and it'll be good practice for you. All right, so back to, I think we're kind of on the Statsky section, but remember the procedural history, the prior proceedings. How do we get here? And in Gideon versus Wainwright, our legal issue arises from the procedural history, and actually, so in Peterson too, right? There was a motion to have these statements admitted into evidence, under an exception to the rule against hearsay, and, that was denied, or for at least, what was it, 8 of the statements? So that becomes the legal issue. So it's not that Peterson allegedly murdered his wife, but how did we get here? How did we get to the appeal? Okay, so remember, it can be important because it can actually be what the court is reviewing here. Um, and sometimes the procedure gets super complicated if you look back to that triplet case where the Social Security benefits, there were 2 appeals from the Social Security benefits, and then it was appealed to the court and blah, blah, blah. Um, remember when, usually your reported decisions are appellate court decisions. So they're talking about what's here. So that's what's in this decision that they're writing. And if they talk to what happened prior, they call that below. Um, remember the interlocutory appeal. I think this is going to be a quiz question. So remember what it is. You're always going to do things after a final judgment. That's when you can appeal. There has to be an order. So this is after a final judgment, after the jury gives a decision and the court does a final judgment. That's your traditional way of having an appeal granted. But if there's an appeal of an order before final judgment, we call that an interlocutory appeal, like Peterson. So if you are briefing a U.S. or Supreme Court or Illinois Supreme Court decision, the the ruling that you are questioning is the lower appellate court, so the Illinois appellate court or the federal appellate court. Okay, so facts, information about a person, thing, or occurrence. Our rule of law is our enforceable pronouncement that establishes a standard of conduct. So that gives us, applying this fact into a rule of law, gives us our conclusion of law. Okay, and we call that the holding, the conclusion of law in an opinion. We call that the holding. Answer to the issue question. Okay, I'm going to take a break here, and come back in the next lecture.